On a gray November afternoon in Louisville, beneath the twin spires of Churchill Downs, the kind of moment that defines careers was unfolding. Hold My Bourbon, a strapping 3-year-old colt bred for speed and grit, was leading the field in the home stretch. With a furlong to go in the 1-mile allowance race, the bay son of Anchor Down was 2.5 lengths clear of his nearest rival. In the irons sat veteran jockey Luan Machado, a familiar name on Kentucky's racing circuit, known for his calm, methodical rides and strong finishes. Spectators leaned forward, sensing victory for the Colts' connections, Gray V Train Racing and Westbrook Stables of Versailles, Kentucky. The purse was generous, over $130,000, with nearly $73,000 to the winner. But just as the crowd's anticipation reached its peak, something strange happened. As they neared the wire, Machado appeared to ease up. He loosened his hands, took a light hold of the reins, and, in a gesture that bewildered onlookers, patted Hold My Bourbon on the neck just before the finish. A split second later, the chestnut horse Lightline surged up on the outside. The two crossed the wire almost together. The photo finish told the story. Lightline by a neck. The grandstand murmured with confusion. Some blamed the jockey. Others chalked it up to bad luck, the kind of heartbreak racing delivers daily. But for owners Todd and Angela Lewis, the defeat felt personal. And months later, it would become a lawsuit. In December 2024, Gray V Train Racing and Westbrook Stables filed a civil suit in Kentucky's Jefferson Circuit Court against Machado, alleging that he had breached his contract and shown negligence as a licensed professional by failing to ride Hold My Bourbon to the finish line with full effort. They claimed his actions cost them $47,560 in lost purse money and $3,000 in Kentucky Breeders' Incentive Funds, a total of more than $50,000 in direct damages. But beyond that, they argued that the Colts' future value as a racing and breeding prospect had been diminished by the lost victory. In essence, they were asking the court to determine what might have happened if a jockey had simply ridden harder. The plaintiff's complaint was bold, perhaps unprecedented. In the long and unpredictable history of thoroughbred racing, a sport built on risk, luck, and judgment, few owners had ever taken such a dispute into a courtroom. Their argument rested on a single belief, that Machado's decision to ease his horse had cost them a win. For Machado, the lawsuit landed like a thunderclap. Born in Brazil and seasoned on tracks across North and South America, he had built a reputation as a skilled, level-headed rider, the kind who stayed out of trouble and earned trainers' trust. But he was also human. And like every jockey, he lived in a world of split-second choices, where instinct, fatigue, and horse behavior blur together in real time. Just a month before the Hold My Bourbon race, Machado had already faced scrutiny for a similar incident at Keeneland. Riding Ultimate Strike in a 9 furlongs dirt race, Machado misjudged the finish line, mistakenly thinking it was at the 16th pole, a common confusion at Keeneland, which uses 2 different finish lines for races around 2 turns. Believing he had won, he stood up in the irons as his horse coasted, only to be caught and passed in the final strides. The stewards at Keeneland called it an error in judgment, fining him $2,500 and suspending him for 3 days. So when the Churchill Downs race occurred just weeks later and Machado again appeared to ease too soon, racing officials reacted swiftly. On November 30th, the stewards issued a ruling: a 4-day suspension and $1,000 fine for easing up on his mount approaching the finish without adequate cause, second offense. That was supposed to be the end of it. In racing, such disciplinary actions are routine, a way of upholding professional standards without dragging the sport into courtrooms. But for the owners of Hold My Bourbon, the official penalty wasn't enough. They wanted accountability in dollars and law. Represented by Kentucky attorney Andre Regard, the plaintiffs argued that Machado's conduct was not merely a riding error, it was a violation of professional duty. They framed the issue not as a question of racing judgment, but as one of contractual responsibility. When an owner hires a jockey, they argued, there is an implied agreement that the rider will perform to the best of their ability, making every reasonable effort to achieve the highest possible placing. By easing up before the wire, they said, Machado had breached that obligation. Their filings claimed financial damages in 3 categories. Lost purse money, since second place paid $25,400 instead of $72,960. Lost breeder incentive funds, totaling about $3,000. Unliquidated damages, tied to the colt's reduced market value and the potential loss of prestige for Westbrook stables. They even cited the video replay of the race, showing Machado patting his horse as Lightline closed the gap. To their mind, the evidence was visual and irrefutable. But to the court, and to anyone familiar with the chaos of a live race, the issue was far more complicated. Judge Jennifer Bryant Wilcox, presiding over the Jefferson Circuit Court, was faced with an unusual question. Can a jockey be held legally liable for a split-second decision made in the middle of a race? Her answer was no, unequivocally and permanently. In an opinion issued in early 2025, Judge Wilcox dismissed the lawsuit with prejudice, meaning it was closed for good and could not be refiled. Her reasoning struck at the heart of both the law and the sport itself. There is no certainty in horse racing, she wrote. The court agrees with defendant that courts are not the appropriate forum to debate or try to determine the outcome of sporting events. She warned that allowing such lawsuits to proceed would open a dangerous door. Permitting litigants to bring lawsuits and scrutinize an athlete's every move would place the type of additional pressure on competitors that could seriously harm competitive sports like horse racing, Wilcox wrote, citing Yost versus Longo, a California precedent. Her words resonated beyond the immediate case. Jockeys, she observed, operate under immense physical and mental strain. Their choices in motion, when to urge a horse, when to steady, when to protect their own safety or that of their mount, cannot be second-guessed in court without undermining the very nature of competition. Jockeys make split-second decisions during races that can affect their personal safety and the safety of the horses they are riding, she continued. As a matter of public policy, these decisions should not be clouded by concerns that they could face thousands of dollars in legal fees every time a horse owner or track bettor thinks the jockey should have done something different in the heat of the moment. In short, she declared, the courtroom is not the racetrack. A dismissal with prejudice is the legal equivalent of closing the gates. It means the case has been resolved on its merits and the plaintiffs cannot try again. But that doesn't mean they have to accept defeat. Within weeks of the decision, Gray v. Train Racing and Westbrook Stables filed an appeal, seeking to overturn Wilcox's ruling and revive their claims. Attorney Andre Regard confirmed their intention to challenge the dismissal, arguing that the court had overlooked key contractual principles. Still, most legal observers believe the odds are long. The principle of judicial restraint in sports outcomes is well established, not just in horse racing, but in baseball, football, and other competitive arenas. As one Kentucky racing lawyer put it, if you let owners sue jockeys for every questionable ride, the sport collapses. Every beaten favorite becomes a potential lawsuit. The lawsuit's implications ripple far beyond one lost race. For jockeys, it raises a chilling prospect, that their every decision could one day be scrutinized in court, not just by stewards or racing commissions, but by civil judges unfamiliar with the unpredictable nature of the sport. A misjudged finish line, a split-second hesitation, a pat on the neck. Each of these could, theoretically, become grounds for litigation if owners start framing racing mistakes as contractual breaches. The Jockeys Guild, which represents riders across North America, has long warned about the psychological pressure jockeys face. Balancing self-preservation, horse safety, and owner expectations is already an act of daily courage. The added threat of civil liability could make that balance impossible. As one veteran rider said privately, you can't think about lawsuits when you're going 40 miles an hour on 200 pounds of muscle. If that crosses your mind, you're already in trouble. Judge Wilcox's ruling, then, was more than a legal victory for Machado. It was a statement on behalf of an entire profession. Horse racing, more than most sports, thrives on uncertainty. The thrill lies in its unpredictability. The idea that no outcome is guaranteed, no favorite is safe, and no race is over until the wire. Owners know this. Bettors live for it. Jockeys endure it. Yet in recent years, the industry has wrestled with growing scrutiny over accountability, from race-fixing scandals to performance-enhancing drug violations. The Machado case unfolded against this backdrop of tension, where the line between mistake and malfeasance can sometimes blur in the public's eye. But even amid that scrutiny, few believe that racing's natural chaos can or should be litigated. As Wilcox reminded in her ruling, courts are not the appropriate forum to debate or try to determine the outcome of sporting events. For Luan Machado, the ordeal was both professional and deeply personal. After the Keeneland and Churchill Downs incidents, he became a target of online criticism. Racing fans, emboldened by slow-motion replays and betting losses, questioned his motives. Some even accused him, unfairly and without evidence, of intentionally losing. Those close to him say the scrutiny took a toll. "He's one of the hardest-working riders I know," said a fellow jockey at Turfway Park. "People forget these guys ride 10 races a day every day. They're exhausted, and one small mistake gets magnified." Behind the headlines and court documents is a man whose livelihood depends on trust, from owners, trainers, and fans alike. And in the insular world of racing, reputation can be as fragile as a photo finish. Machado's defenders point out that, despite 2 misjudged rides in a short period, his career spans hundreds of mounts without incident. They see the lawsuits and suspensions not as patterns of misconduct, but as painful lessons in a profession defined by razor-thin margins. As for Hold My Bourbon, the Colt's story continued quietly. Though denied that November victory, he remained a promising runner, his connections hopeful for redemption. Yet the legal battle over his defeat underscored a broader truth. In racing, the value of a horse often extends beyond the track, into breeding rights, marketing, and pride. Owners pour fortunes into their equine investments, and a single win at Churchill Downs can elevate a stable's standing. Losing that win, especially under controversial circumstances, cuts deep. But as the court reminded, passion and proof are not the same thing. The case may prove to be a landmark in modern horse racing law. If upheld on appeal, it will reaffirm that the courtroom is not the venue for second-guessing athletic performance, that sports must remain governed by their own rules, not civil litigation. And if overturned, it could open a new chapter of legal exposure for jockeys, trainers, and even referees across professional sports. Either way, it has forced the racing world to confront a difficult question. What does accountability look like in a game built on chance? As of early 2025, Judge Wilcox's words still echo in the Kentucky racing community. Jockeys make split-second decisions during races that can affect their personal safety and the safety of the horses they are riding. These decisions should not be clouded by concerns that they could face thousands of dollars in legal fees. It's a ruling rooted in both law and empathy. An acknowledgement that in the fleeting chaos of a race, even the smallest motion carries weight. But not all of it can be measured in money or blame. For Machado, it means he can keep riding, learning, and hopefully healing his reputation. For the owners, it's a bitter lesson in the unpredictability of the sport they love. And for horse racing itself, it's a reminder of what makes it endure. Not perfection, but the fragile human drama that unfolds every time the gates spring open. Because no matter how much money is at stake or how high the stakes climb in court, there is, and always will be, no certainty in horse racing.